So the number of companies, both public and private, that are planning retrenchments is growing, as we indicated. So Trade Union Federation COSATU describing it recently. The situation itself is worrying. There are job losses expected in the mining and retail sectors, while airlines SAA and COMAIR are in trouble. Not to mention here at the SABC too. It's a stressful time for employees and a desperate time for job seekers, with added pressure which is caused by the COVID-19 pandemic. Let's chat more a bit about this. Labour attorney Natasha Moni joins me now via Skype to navigate through all of this. Natasha, thank you very much for joining us here on The Full View, and good evening to you.
Thank you. Good evening, Christelda.
Natasha, so look, a lot of people will lose their salaries. It's quite worrying. What is the onus on these companies in terms of what they should be and how they should be communicating with employees during such a stressful period?
As soon as they contemplate retrenchment, they need to tell their employees, they need to bring to the table why they believe that their jobs are on the line. And in such a respect, they do that in terms of a letter. The letter is prescribed by law. But basically, they must have made a decision that has a commercial rationale, because at the end of the day, it has to be a viable and fair and reasonable position that they're in order to take such a huge step. There's a difference between a normal retrenchment and a retrenchment that is a large-scale retrenchment, Christelda. A large-scale retrenchment means that one would have to go to some form of facilitation at the CCMA in order, and that happens for 60 days, in order to try and see if the large-scale retrenchment is necessary.
So that would be something similar to like what is being proposed here at the SABC. That large scale would fall into that. And I see also that there is an element of facilitation that is also put forward in what the SABC has brought to the table. Talk to us a bit about that large scale retrenchment.
Large-scale retrenchment is when you're retrenching in terms of Section 189 capital A, as opposed to just Section 189 of the Labour Relations Act. What the SABC has asked for facilitation right up front, which means that it really is trying to become lean and mean by the end of September. Now, I have a problem with that, because when you are trying to negotiate, it is a consensus-seeking consultation process where parties have to agree. And one of the agreements that you have to come to is the timing of the dismissal. So that can't be placed on the employee, and you can't be told, oh, well, this is going to happen until September. So already you can see that there is something going on here, and it's no wonder that the unions are saying, this doesn't sound right. We believe that we've lied to you. There are other things that one can do in order to try and see whether or not the reasons for the retrenchment are good enough. And those are to actually ask any company, whether you are in a Section 189 retrenchment or a large-scale retrenchment, the reasons for the retrenchment. For instance, if your company says there is a strategic plan that we put in place and we're going to follow that strategic plan, well, they should attach the strategic plan to the reasons for wanting to retrench you. If they say that they have a new organogram, well, they need to attach the new organogram to the letter that they've given you, so that you can see whether or not, in terms of your position, one, if you are going to be affected, and two, whether or not you can find any alternatives to save more positions.
Natasha, what does the law say about, about retrenchments during COVID-19? Because if I look at one of the examples, Edcon was in trouble before the pandemic. So what would be the difference there?
Well, then, the good thing about, they've gone into business rescue. And so, and so has SAA. And the good thing about being in business rescue is that normally any person that has litigation against their debtors, when the creditor is in business rescue, it stops. And also, in terms of business rescue, the employee becomes a sort of a preferential creditor. So the business rescue practitioner has to, in terms of the rescue plan, take care of those employees. So it's a better position to be in than had the company just closed down. But what the Labour Court has said with regard to SAA's business rescue practitioners attempting to go through the retrenchment process is, wait a minute, guys, you have to still do this properly. And that's the wonderful thing about the large-scale retrenchments, is that if the trade union, the company, is not doing the process or conducting itself in accordance with the Act, they can then take the company to court and ask the court to place them back in the position that they were before the process started, so that they can start the process again. And that gives trade unions and your business rescue practitioner, especially in the case of SAA, pause to consider the seriousness of their reasons and to consider the seriousness of the process that they need to undertake.
Natasha, we're really running out of time. Just very quickly, so why does it seem like some of these companies don't have, a couple of months fallback plan? This is certainly what we seem to be gauging from most of these companies.
Well, the retrenchments are no-fault dismissals. So basically, you look to your directors and you look to the board and you say, guys, you got a huge bailout last year. What have you done with it? You paid out millions of rands for a sexual harassment inquiry. What came of that? There are people who are misconducting themselves all the time. Why have you not gone after them? Why are there no dismissals? Surely you should mitigate our risk of losing our jobs sooner rather than later. Also, just one thing, I know that the youth are going to lose their jobs. And the reason why the youth will always lose their jobs in a retrenchment exercise is because last in, first out is seen as the most reasonable selection criteria in a retrenchment. So if you are young, I would suggest that you look at you look at these things very, very carefully, and perhaps consider a voluntary retrenchment.
Natasha, as hard as it is, certainly not good news, but thank you very much indeed for your insights. Always great hearing from you, Labour attorney Natasha Moni, talking to us about retrenchments during this time of COVID. Of course, COVID exacerbating job losses, the jobs bloodbath in South Africa. A number of companies, coming to the fore, saying that they're going to retrench. We'll take a short break here on The Full View. Much more coming.